letting your eyes down, but I know there's always a way. From sunrise till dawn, I'll be here waiting. From sunrise till dawn, I'll never stop. I'll fix you up, make everything much smoother again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. The connections might be tangled, the power source has lost its spark, but every wire tells a story, and I can mend what's torn apart. From sunrise till dawn, I'll be here waiting. From sunrise till dawn, I'll never stop. I'll fix you up, make everything look smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. When the current isn't flowing, when the signals disappear, I'll be here with tools and patience, make the static crystal clear. Every cable, every circuit, every problem that you bring, I'll restore what time has broken, make the whole world sing. So don't you worry about tomorrow, don't you stress about today. I've got maintenance for your troubles, and I'll chase them all away. I'll fix you up, make everything run smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. Hey, Daniel, everything's good as new. Hey, Daniel, I'll fix you up for you.
Well, welcome to the show. I am your host, Daniel, and today is Judge Middleton. I kind of moved everything around a little bit. I kind of changed it up a little bit this last week. Try to showcase different judges and not the same thing over and over again. I'm trying not to be boring, but in my opinion, showing this stuff about the courts and real court cases and real judges and what happens in the courts is a good thing. This is where you can learn. This is where you learn something about the American justice system. I know this channel is, I thought about this last night. You know what? If this channel doesn't grow, it doesn't grow. It could be boring forever. I'm not worried about this channel growing. I'd like to see it grow. Maybe it'll catch on. Eventually, we'll catch on one day. But I'm not promoting my channel on other YouTube channels. I don't plan on it. And I'm not going to give up. Monday, I have a doctor's appointment, so that stream will be moved down to that stream will be at 7 o'clock, and Tuesday is my birthday. I think we're just going to be a regular, whoever's on the docket that day. So today is Judge Jeffrey Middleton. So he's one of my favorite judges. I like this guy. So let's get this started. Share screen. Filming. Share. Make this bigger.
Are the Yoders here?
I have.
Somebody filed something. Did you get a copy of this, Lance?
I did. Somebody handed it to me, but it was not the Yoders that handed
Oh,
it to me.
okay. Well, I just got it a minute ago, so. All right, well, it is the appointed time. It's 2:02. Let me call these cases. Get them set out here. There are matters in two separate cases before the court. Oh, yes, thank you. Everybody may need to scooch down. There are two separate matters before the court here today, and there are several things that we're going to need to address. The title of the cases, for starters, is Colon Township versus Joanne Yoder, which is 25533CZ, and Colon Township versus Alfred Yoder, which is 25533CZ. There is a preceding case, Colon Township versus Alfred Yoder and Joanne Yoder, which is in file 252040CZ. In 25040CZ, there is a permanent injunction in effect that was ordered by Judge Stutzman earlier this summer in July. And the defendants were compelled to appear at a show cause hearing, and they failed to appear. And Judge Stutzman issued bench warrants for their arrest. The way I read the petition is for civil contempt, set bond at $1,000 cash in each case. I believe last Friday, I found out about this on Monday. The defendants apparently presented themselves at the jail on August 22nd, posted $1,000 cash bond in each case, and were given a notice to appear for today for the show cause contempt in file 25040CZ. Plaintiff Colon Township has filed a brief in support of a motion for preliminary injunction, actually requesting a permanent injunction, and file 25533CZ. These are two separate parcels of property. 25040CZ is 30158 Marsh Road. I believe the property known as Mama's House, which has been in operation for some time. The second case, 25533CZ has the same addresses, but it is a different parcel of property very near the other property on Marsh Road.
It actually has a separate address.
Adjacent to,
30246.
what is the number?
30246 Marsh Road is the 533 CZ case.
All right.
Now the Yoders live at 30158.
All right.
That's their address.
This is adjacent. All right. Now, preceding all of this, all right, we'll get a little background. This matter has been pending before Judge Stutzman, and he's had several hearings in this matter. Judge Stutzman is a circuit court judge, and this matter was filed for hearing in the circuit court. Judge Stutzman made some rulings and issued these two bench warrants. Sometime after the bench warrants were issued, I was assigned by the Supreme Court to hear this matter. Judge Stutzman has disqualified himself for reasons that are known to him. And he actually called me while I was on vacation and asked me while I would take this case. And I said, yes, I would. So Mr. Thornton has filed a motion to, I guess, reassign me or disqualify me under the theory that the matter should have been assigned to a circuit court judge. And so we have to deal with that before we deal with anything else. Once the order of disqualification was entered, Judge Stutzman signed it, Judge Pattison signed it. I don't remember whether Judge Kane did. I had already agreed that I would take it. Mr. Thornton, you're aware of this. St. Joseph County is part of a concurrent jurisdiction plan. That was entered on January 16th of 2013, and I'll provide you with a copy of that. And the concurrent jurisdiction plan indicates that the benches will share obligations. There is a statute, 600.8304, regarding jurisdiction. In a district court district, which the district court is affected by a plan of concurrent jurisdiction adopted under Chapter 4, the district court has concurrent jurisdiction with the circuit court or the probate court, or both, as provided in the plan of concurrent jurisdiction. So just before you folks all came in here, I did a personal protection order matter, and I've done dozens, maybe hundreds of them. Those are circuit court matters, and we are all cross-assigned under our concurrent jurisdiction plan, and all 4 judges actually do personal protection orders. And I do my share, and I had one just a few minutes ago. On a number of occasions, I have covered circuit court matters in criminal disqualifications. I'm the primary backup for Judge Stutzman if he has a case in which he has to disqualify himself in a criminal case. So those are felonies. I've handled a number of those. I'm also his primary backup in zoning cases. And he's had several occasions over the years where he's had to disqualify himself in zoning matters. He disqualified himself in Lockport Township because he lived very near where the property at issue was. Recently disqualified himself. He moved to Fabius Township. And they had a complicated matter regarding solar farm. And he was disqualified. And I was assigned by the Supreme Court and our chief judge to hear the matter. So Mr. Thornton has cited some of the case regarding that, but Mr. Thornton, I do not believe it would require that I not be eligible to handle this case. I'll ask you if you have any other comment, but it's my intention to deny your order to reassign a judge. What would happen is it would then go to the next judge, who would be Judge Pattison or Judge Kane, who would know even less about this than I do. But I don't feel like I know less. As you know, we do lots of zoning cases of all shapes and sizes. And so it's my intention to deny your motion, but is there anything else you'd like to place on the record?
I appreciate the court providing me with a copy of the concurrent jurisdiction plan.
Do you have one yet?
I do.
Okay,
I
yes,
do
so we think
have
we said
that.
that.
So not sure I agree with the whole concept, but I understand the law. I've read it and read the concurrent jurisdiction plan. I understand it, and I understand that it provides that this can happen. Before Your Honor actually rules, though, I would just like to inquire, because it does appear that Judge Stutzman said he had a conflict. Judge Pattison has indicated he has a conflict, had some knowledge or had spoken with the Yoders or their friends or both. On behalf of the township, I would just ask if Your Honor feels like there's anything that he knows or has been introduced to that would cause conflict for Your Honor in this matter.
Well, that's a fair question. In the last case, I represented that I was going to dinner at Farron Hall shortly after our hearing. That was an issue that I raised myself. The answer is no. I know very little about this. I was at a county commission meeting when a number of people got up and spoke at the commission meeting about this issue, and that was the first I even heard of it. I don't know any of the parties. I know very little about it. I have not discussed it with Judge Stutzman, other than when he called me and asked me whether I would accept the assignment. So no, I don't know the facility. I've never had a case involving Mama's house to my knowledge. I don't know Joanne Yoder. I don't know Alfred Yoder. Lord knows I would be more than happy to foist this off on another judge down the line, but I don't feel I have justification to disqualify myself. So for the record, I don't know the parties, know very little about the case. In fact, I was totally uninformed when the parties were at the commission meeting speaking about it. I asked my administrator, she had some knowledge of it, but so the answer is no.
And I accept that, and so I'll just let the court make its ruling on my motions.
All right, I will do a formal order denying your motion in each case. So that's our first order of business. Our second order of business is to deal with the bench warrants. Because I didn't know anything about this case, I had to familiarize myself with the file. And so I spent some time going through both files, 25040CZ and 25533CZ. Things are mostly done in the 25040 case. Judge Stutzman entered the judgment of permanent injunction on, can't read it, March 13th, I think it was. So that case has been decided. However, there was a show cause and then there was another show cause. And he issued 2 bench warrants. And then I was confused because the bench warrants were issued by Judge Stutzman and the clerk on, I believe it was July 7th. And the Yoders were personally served by Sergeant Morse from the Sheriff's Department later in July. At the time they were served of the notice for this hearing, they were open bench warrants for their arrest. I had a question of why weren't they arrested when they were served with the warrants? And I don't know that I got an answer to that. I don't think they wished to have a confrontation. I think there'd been some discussion about having them present themselves in the warrant, but a sheriff's deputy had personal contact with the defendants while the bench warrant was in effect, but it was not served.
My understanding is Bruce Morris doesn't conduct arrests anymore.
He does not, but he would. He doesn't. I don't want to. He does a wonderful job for us, as
Yes,
you know.
he
He
does.
handles our service, and he makes my life much easier by being so competent and professional. But at any rate, he is still deputized by the Sheriff's Department. Anyway, so eventually the Yoders presented themselves at the jail on Friday the 22nd. We're given notice to appear today, and they're not here today. They posted $1,000 cash bond, each of them, and filed 25040. And there's a notice from the sheriff to appear today at this time and date, which is good because we were already scheduled to be here today at this time and date.
I wasn't aware that anything had been set for today for that particular issue.
Yes, let me see, I think I copied the notices. They were given notice by I can't read the deputy's name. I guess I saw the original copy for August 29th at 1400 hours, failed to appear on the show cause. So they aren't here now. A number of other people are here. So I can't arraign them on their bench warrants because they aren't here. Someone was here earlier this afternoon, and these were signed and date stamped August 29th. I received what I is entitled response in file 25040 and uh, 25533CZ. So the allegation is that the defendants were in civil contempt for failing to appear for an order to show cause, and now they failed to appear pursuant to a posted bond for an arraignment on the show cause. Mr. Thornton, what's your thought in that regard?
My thought first with the responses that have been filed today, as the court has pointed out in 25-040 CZ, there really isn't anything to respond to in that. So I don't know what the court wants to do with that. With the response today attempted to be filed in 25-533 CZ, the
Well,
orders are.
let's stick to 40 for a minute because that's where the bench warrants are.
Okay.
I'm unhappy that they're not here. I never met them. I don't know them. I don't have any prejudgment about it. Judge Stutzman issued those bench warrants. There was criminal or civil contempt. My inclination is to issue a bench warrant for criminal contempt for failing to appear pursuant to a posted bond and set bond at none. No bond until I see them. They will appear at the jail or be arrested by the sheriff and be held in custody until such time as I can conduct an arraignment. I don't like somebody poking me in the eye with a sharp stick. Judge Stutzman ordered the bench warrants. They did appear and present themselves. They posted $1,000 of cash in each case. Civil contempt is punishable by up to $7,500 in fines, but not a criminal punishment. Now they failed to appear pursuant to this. Now this is a civil contempt in a zoning case. The Criminal Justice Reform Act changed the rules a little bit as to bench warrants in criminal cases. As a rule, we are to give 48 hours of grace before the bench warrant issues in a criminal contempt case. Failed to appear on a bond. And so my inclination, Mr. Thornton, is to issue 2 new bench warrants with no bond until they're seen by a judge, namely me. And give 48 hours. In fact, I would start the 48 hours on Monday. So they'd have until 5 o'clock on, well, Monday is a holiday. I would grant them until 5 o'clock Wednesday, September 3rd to appear.
And I'm fine with that, Your Honor. In that case, as the court's pointed out, we do have a permanent injunction. The birthing center is not supposed to be in operation, and it's my understanding it is still being operated.
We haven't taken any testimony regarding that, but that would violate the permanent injunction and subject them to further contempt if it is still being operated. Anyway, I'm going to issue a bench warrant for Alfred E. Yoder for failing to appear pursuant to a posted bond in a contempt matter. I'm going to set the bond at no bond until such time as he sees the judge. He has until Wednesday, September 3rd, to present himself at the court. I would order the exact same matter in Joanne Ann Yoder. I find she's in contempt for failing to appear at this hearing. It's not accidental contempt, it's willful contempt. They don't recognize the jurisdiction of the court. We have a fundamental disagreement on that subject. But if they don't appear this time, they're going to sit in jail until such time as I can see them. So one for Alfred E. Yoder, one for Joanne Yoder. All right, so that finishes 40 CZ, 2540 CZ. That's the case that's done with a permanent injunction. That's on Mama's house. That's the bench warrants were in that case. The other case that it needs to be addressed today, which was set for hearing, is 25533 CZ. That is the other property where something was being constructed, I believe, to supplant or replace the facility that was used for Mama's house. The lawsuit was filed on July 22nd of 2025. The defendants filed no response. We'll talk about today's response in a minute. And the clerk sent out a notice of entry of default on August 22nd. They waited 31 days rather than 21 days, sent out a notice of default. So the matter was set for hearing today. They did not file a response in a timely manner and would be subject to the entry of a default granting the relief requested by the township.
Yes, she is in trouble. We're both in trouble. If you don't show up, if the court orders you to be present in court in front of that judge and you don't show up, it's considered contempt of court, and it will issue a bench warrant. These judges don't play. It's not like the Florida judicial system where everybody gets away with murder. Technically, BBB should have been locked up. A bench warrant should have been issued, and he locked up until such time. John don't want to hear that, but that's the truth. He was in contempt of court. He didn't show up for a court hearing. Exactly. If a court orders you to be present at a certain date at a certain time and you don't show up, it's contempt of court. Yes, I'm watching, but I'm not watching the chat. So you guys behave yourself, because Trin will zap you. It's like I said earlier. Everybody is welcome here. The only thing that I ask the people who come into this chat and come into my channel is you act like you're in a court of law. You act accordingly, like you're in a court. Some people don't even do that. If you watch Judge Bryant by Judge Bryant snapped at people because they were acting inappropriate in court. Judge Webster, the guy was in contempt of court, and she didn't play that. Neither am I. I'm in a t-shirt. All I ask is that people act accordingly. That's why the no-fly list has been removed. But I will tell you, I might reinstate that no-fly list. I don't like the behavior of certain people in other chats. Now, I've been nice to everybody. As far as I know, no. No. I've been thinking a couple times this week that I wanted to quit doing this because nobody is coming to the chat. Do you think that I think people should know what is expected in court. There hasn't been any drama. It's just certain people are showing up in certain chats. I know one of them is a troublemaker, and she probably needs to be banned again. But see, I don't want to do that. I want everybody the opportunity. I believe in having second chances, but in my opinion, yes, I take 100% responsibility for what happened on the channel. However, I want people to understand that I had no clue what was going on, and I got caught up in it. And it makes me upset because I lost my friendship with somebody that I was close to, and I'm never going to get that back because of what they did. Hey, Linda. Oh, that Pepsi's good. Oh, let's get back to Judge Middleton. Like I said, I'm watching this to make sure there's no ads or anything. But this is what is being presented. This is what I'm doing on my channel. I'm letting people see what the judicial system is and how the judicial system is supposed to work. And I think that what I'm doing on this channel, I'll tell you what, it's a lot easier to do this than to sit there and talk about drama all day long. And I don't know whose idea it was to do the court stuff, but I appreciate that. I think it was Linda, wasn't it? I think it was Linda that said something about doing courts and court cases and stuff like that. I've been doing it for over a month now. Yeah, some of them get views. Some of them have been getting a lot of views. But somebody suggested that it might have been it could have been it could have been Gail that suggested it. I don't remember. You know how many live streams I've done since I've started this channel? Over 140. When I started this channel and I was able to do live streams, so far up to date, I've done over 140 live streams since I've started. It could have been Gail. It could have been that other lady. But the thing is, I'd rather do this than talk about drama. And to be honest with you, I get tired of hearing it. After a while, I have to turn off Tug and Megan because it's just, it's turning into a real shit show. I heard there was a meltdown on the other side. It's what's funny is this channel, she got struck twice. I believe she got struck. No, she got struck. No, she got struck twice. No, she got struck three. I know that she got struck 3 times. I know one time she was doing a live stream and somebody reported it and her channel got stopped in the middle of a live stream, but that was it. Then you got all that debacle with all the videos. She got struck for that. And then she got struck again. It's not going to be, she better be careful. If you want to keep your channel going, you don't need to be doing bad things. Mr. Rogers. Hey, Mr. Rogers was a better father than my own dad. I like Mr. Rogers. That was a true teacher, Mr. Fred Rogers. I grew up watching him when I was a little baby. When I was a little kid, I used to watch Mr. Rogers' Neighborhood, and I used to watch Sesame Street. Remember the Electric Company? So yeah, talking about courts and court cases and the judicial I can't talk today. Judicial system is a lot less stressful on me, and I'm getting all kinds of content. So yeah, I'm getting a lot of content for this. I have a lot of Judge Middleton. I have a lot of Judge Boyd. I did Judge Boyd yesterday. I did Judge Webster. I'm going to have to work on Judge Manning. That's something I'm going to have to look for and see if I can't. That lady doesn't play either. Judge McNally. I like Judge McNally. Yeah, I'm getting quite the views on the replay. Some of them do have views, some of them don't. And this is a reminder. If there's anybody on here that's not a subscriber to this channel, please consider subscribing to this channel and helping this channel grow. I would appreciate it. Trin would appreciate it. Everybody would appreciate it. So let's get back to Judge Middleton. Oh, I was looking up something too on the what's coming up after this, Farron Hall. It's like a bakery type restaurant thing in Colon, Michigan. Their food looks good. And yes, there's a train coming down the tracks. That I can't help. Yeah, I want to work on that, Judge Manning. But let's get back to Judge Middleton.
I received today, in that case, something entitled response. I read it. I'll accept it for filing. It doesn't meet the standard of a legal answer to a civil complaint. It's got some archaic language. It's got a fingerprint.
May I speak on that?
Yes.
Being in default, it's my understanding under the court rules that an answer cannot be filed and accepted by the court until the Yoders would file a motion and show a meritorious defense through affidavits or testimony.
Well, what we're going to do, I'm going to grant your default. Now that we need a default judgment. The entry of the default is in there. What we would need to do is.
After that guy. Was that filed in my office?
It was stamped by Gina Everson.
I don't know if it was filed.
And it doesn't. I wanted to make sure that it wasn't, it's titled a response, so my clerks would not have put it in as anything other than a response. Would not use that as an answer.
In district court, we're much more flexible. We take handwritten answers, as you know, in civil stuff and grant the people a day in court. Well, this, whatever it is not filed in a timely manner. So we have a notice of entry of default signed by the clerk on August 22nd. What I need for you to do is move to enter the judgment of default as to each defendant. Your pleadings in that case. Now, the motion for today is for entry of a preliminary injunction. And you did a good job in your brief of setting out the standard for preliminary injunction and what it is. And it's not to be granted lightly, but it's based on the likelihood that the plaintiff will prevail in the ultimate hearing. In your actual motion, that's filed with the court, the relief request, that on page 9, you request permanently enjoining the defendants, agents, servants, assigned successors in interest, or those active in concert or participation with them from using the subject property as a birthing center. This is the adjoining property. So the complaint requests a permanent injunction. They have not responded to that in a timely manner.
I can address this, Your Honor.
Yes?
What I'm going to request today is that pursuant to Court Rule 2.111 E1, the detailed allegations in the complaint, and they are detailed, are now admitted by the defendants due to the default. And the defendants cannot proceed with the action until the defaults are set aside under Court Rule 2.603A3.
And I agree with that.
And
so what we need to do is your pleadings stand as accepted. No answer. And your pleadings include your signature as the attorney for the township. Once we enter the judgment, And you're asking for the permanent injunction?
Well, I was asking today for the preliminary injunction to be entered based on the fact that they're not here to defend, they're in default, and all the allegations in the complaint and the supporting documents are at this point admitted by the defendants. What I intend to do then is, let's see, provide under 2.603B1 of the default court rule. I may not be required to do so, but on the just being overly cautious, I will prepare a permanent, a default judgment with permanent injunction, which I have not done yet, but will soon. And I would submit that, send notice to the Yoders, and then set that for hearing and have the court enter it at that hearing.
All right, so what you're asking me to do by default today is enter the preliminary injunction.
That's correct.
All right, I will so order as requested.
And Your Honor should have a proposed preliminary injunction order.
I have the brief and I have the judgment. Let me see if I have the order in here. Do you have a copy?
I do.
By default, the court finds that the defendants failed to file a response in a timely manner to the lawsuit, which was within 21 days. They've also failed to appear at this hearing, which also subjects them to default. This is the 29th day of August. This preliminary injunction order states the court makes the following findings. I'm going to have to change the name, but Colon Township is likely to succeed on the merits of its claim against Alfred E. Yoder and Joanne Yoder with regard to the alleged violations of Michigan's construction code as cited. Defendants are the owners of the following described real property, and that is the subject of this case. And the property is described by a legal description in the order. It's also known by a common address of 30246 Marsh Road, Colon. A building being constructed on subject property without building permits and inspections by qualified building inspectors represents a dangerous situation that could easily result in irreparable harm to persons using or visiting the building, including emergency personnel. The court does lots of these. Routinely, we have zoning violations where people are building things without a permit, garden sheds, additions to their house, garages which are in the right of way of the road. That's routine zoning matters we do in the district court. I'll continue to quote from the proposed order. The plaintiff has no adequate remedy at law. The risk of harm that would exist if the preliminary injunction were not granted outweighs the inconvenience to the defendants caused by granting the injunction. The public interest is furthered and not harmed by the granting of the preliminary injunction. The applicable law cited in plaintiff's brief and support motion for preliminary injunction authorizes injunctive relief under the circumstances. And as I mentioned, Mr. Thornton filed a brief which was well cited with the facts and the law. It is hereby ordered that the above finding facts are hereby, the above findings of fact are hereby incorporated and made a part of this order. Plaintiff's motion for preliminary injunction is granted. The defendants and their officers, agents, service employees, attorneys, assigns, successors in interest, or anyone in active concert or participation with the defendant are enjoined from performing any further work on the interior or exterior of the building being constructed on the subject property unless a valid building permit is issued for the building by plaintiff's building code officials, and the stop work orders that have been issued and posted are rescinded by the plaintiff's building code officials. And occupying the building on the subject property or allowing anyone else to occupy the building unless written authorization to do so is obtained from the plaintiff's building code officials. Colon Township shall cause a certified copy of this order to be posted on the front door of the building of the subject property within 10 days of the entry of this order, and no one shall remove the posted copy of this order from the front door unless and until the removal is authorized by plaintiff building code officials. This order will remain in full force and effect until this court specifically orders otherwise. This property is posted, and there's a copy of it in here, with a prominent no trespassing sign. And arguably posting this on the front door of the property. So you may post this on the trespassing sign,
Right.
where you won't have to enter onto their property over their objection. There's a trespassing sign of some elaborate detail in front of the property.
Or would the court entertain adding to my order that we be permitted to go on to post it on the front door with a
Well,
police
it already
officer?
says that, but I don't want a confrontation.
Well, I would request a peace officer from
All
the,
right, well, then I'll leave it as you drafted it. Signed effective August 29, 2025. This order is entered by default. Failure to answer in a timely manner and fail to appear for the hearing. And Mr. Thornton started to speak to this. When a default is entered, the plaintiff can move to have the default set aside. I believe it's within 21 days of the entry of the default. And in order to do that, you have to show good cause for failing to appear or answer, and you have to show an affidavit of meritorious defense. And this comes up all the time in my court. Late people are being sued by an insurance company or a hospital or an auto lender, and they get defaulted and they don't understand what's going on, and they file an answer in a handwritten letter, but it doesn't rise to the level of the statute to set aside a default. You need just cause for failing to appear at the hearing, and I don't know what that is, because they aren't here, and as I said, I'm not very happy about that. And secondly, they have to show an affidavit of meritorious defense. The document entitled response, I make no finding on whether it is an answer, appropriate answer. Whatever it isn't filed in a timely manner. And secondly, they aren't here to address it. You don't swing by the courthouse 5 minutes before the hearing, drop off a vague pleading, and cover your bases. That's not how it works. They were willing to present themselves on the warrants and post the bond. So I'm disappointed that they aren't here. I had hoped to engage in some sort of dialogue. In true point of fact, they need a lawyer. They need a lawyer who's licensed in the state of Michigan. They're going to end up in jail. There may be legitimate defenses to this. There may be issues that could be explored by competent counsel. They have their own reasons for choosing not to retain counsel, and be represented by themselves, but in the humble opinion of this court, they could benefit from competent legal advice because they're going to end up in jail. They're going to end up in jail unless they appear by next Wednesday at 5 o'clock, because they're going to sit in jail until I get a chance to see them. They were ordered to appear by Judge Stutzman. They failed to appear twice. He issued a warrant for their arrest. They were given a notice to appear today, and they gave me the same discourtesy they gave to Judge Stutzman in failing to appear. So I can't even talk to them. So let's recap. I've denied the township's motion to disqualify myself because there is a concurrent jurisdiction plan in place. I handle these matters in my own court routinely. This is not outside the province of cases that I regularly do. So I'm going to do a written order denying that in each of the two cases. Secondly, I intended to arraign the defendants on the bench warrants in 25040CZ, but they failed to appear. So I issued new bench warrants with no bond. The defendants are allowed 48 hours, in this case, a little more than that, until next Wednesday at 5 o'clock to present themselves either at the jail or at the court. The bond is none. Third, I've granted plaintiff's motion to request a preliminary injunction and filed 25533CZ. Mr. Thornton intends to file a further notice asking for a permanent injunction, and again, giving them an opportunity to respond. But until further order of the court, the preliminary injunction is in place to prohibit any further construction or occupation of the second building. Mr. Thornton, is there anything else we need to do here?
No, I will see the court, Your Honor, Secretary, about getting a date for the next hearing for that proposed default judgment.
All right, very good. It's easier than it was with my schedule, vacation schedule, the judicial conference. We're good now till deer season when Judge Pattison is gone much in November, but we're here for the duration, so it should be easier to find a place to put this than what we had for today.
Shoot, Bambi.
Okay.
All right, this is a public courtroom, and I appreciate that. This matter is also being live streamed. You can watch it on YouTube. It's important to have a public courtroom that people can come into and sit and see what happened. You just saw what happened. You may not agree with it, but it wasn't done in secret. So we'll see how we proceed further. Thank you all for being here today and your decorum.
Okay, I got a bunch of Judge Manning. I found a whole bunch of Judge Manning. So I'm going to be playing Judge Manning Monday. But it's going to be like at 7 o'clock at night because I have a doctor's appointment. Is there any other judge that I'm missing that I need to do research on? I know I got a bunch of Judge Webster. I got a bunch of Judge Boyd. I got a whole bunch of miscellaneous cases too. The schedule is going to be changed up. I kind of change it up. Every once in a while, I'll change it up. Yeah, I like doing these court things. It's like Judge Middleton said. Learning how this process works is important. I might not be getting the watch time hours, but I'm getting the views. So I appreciate the views. I can't think of any other judges. I know there's quite a few of them. I know there's Judge Washington out of the Washtenaw County. I don't know if she's done anything recently or not. She's a good judge. Then you got Judge Frushauer, who's with the Washtenaw County Court. She don't play either, but she's compassionate. So let's get back to Judge Middleton. Let's go to the next case with Judge Middleton. I'll look that up while this is playing. I think it's Irene, Washington. I'll look it up and see if I can come up with something with that. Just a reminder, everybody, if you're not a subscriber to this channel and you like the content that's being on this, like the content that's on this channel, please consider subscribing to this channel and helping this channel grow. That's all I ask. And let's try to get 100. Let's try to get up to 100 subscribers before January 1st of next year. I know we can do it. We still got October, November, and December. And I know we can do it.
Have you been injured in a car accident? If you do, this can...
I'm in on my on base. We have a formal zoning violation matter scheduled for this morning. It's entitled Colon Township versus James John Gray and Jacob James Hagan. Mr. Gray has filed 2510800ON. Jacob Hagan is represented by attorney Casey Strong, and that is file 252078. James Gray, present, and Jacob Hagan, present. Mr. Lance Thornton is here on behalf of the township, and Casey Strong, are you here on behalf of both defendants?
Yes, Your Honor.
All right, for both defendants. This is a matter of some public interest. It involves what we know as Farron Hall, which is a well, we'll call it destination banquet facility restaurant in Colon Township. Mr. Thornton has represented Colon Township for a long time, and Casey Strong is one of the attorneys that practices here in our county. Just as a disclosure, I would let you both know that obviously I've been a patron of Farron Hall. I actually have a reservation at Farron Hall for later this month on a brunch. I think it's on I don't know what day it is. Anyway, it's this month, August. I have a reservation. We're going to take some friends there. So I am a patron. I've been there. And the practical matter, I probably actually parked in the spot that is in contention on Timber Trail Drive. I discussed this with the other judges, and I don't believe there's a need for me to recuse myself because I had a reservation. They indicated if I wanted to give it to them, they would go make a reservation themselves. So in for a penny, in for a pound, but I thought I should disclose that. Mr. Thornton, does that make you uncomfortable or otherwise have a concern about my handling this matter?
It does not.
Ms. Strong?
Not at all, Your Honor.
All right, thank you. All right. This is a formal hearing on a zoning violation. The original citation was issued on June 10th of 2025. Zoning violation of section 26-4. The ticket states, by signing a special land use permit, the permit holder agreed not to park within the easement along Timber Run Trail, which is a private road. And the PO, I'm not sure what that property owner continues to park within the easement and has not finished the parking lot in the time specified by the township. Mr. Thornton has also provided number of other documents in support of that with the filing of the jurat. Casey Strong filed an appearance in this some time ago. Apparently, there's been no discussion. Ms. Strong indicated she offered to speak to you this morning and you declined to do so. I'm not sure what that's about.
Didn't necessarily decline, Your Honor. I just didn't know what we would discuss at this point.
All right, well, let's see where, what's the status here?
The status is the plaintiff, Cohen Township, is ready to proceed with the formal hearing. We've got one preliminary matter. I did issue subpoenas to Mr. Gray and Mr. Hagan last week through their counsel. And I asked Ms. Strong this morning whether any documents were brought here today in response to those subpoenas, and she indicated no.
Were they subpoenas Dukas take them?
Yeah, for production of documents.
I don't have those, so I don't know what they said. All right, well, let's see where we go. They're here. It's your case.
And Your Honor, if I may respond to those subpoenas, those were sent to my office and they were requested that my clients testify at trial, examination, or hearing and produce copies of any and all documents showing number of persons, including guests and employees on the grounds of Fair and Hall on May 25th, 2025. I've spoken with my clients and those documents. There are no records to produce, and I would object to any and all testimony from my clients at this hearing. This is a state actor. This is a zoning violation that has consequences and implications across the board for my clients, and they will not be testifying unless compelled by the court.
All right, well, we'll cross that bridge when we get to it. It is a zoning violation. I'm not sure if it carries a criminal penalty. If it does, they have a Fifth Amendment right not to testify. If it's a civil matter only, they can be compelled to testify. Anyway, there's more going on here than is apparent from the face of this ticket. The courtroom is full of people, I guess, who have an interest, either pro or con the ticket, and it's certainly a public courtroom. Matter is being live streamed, and I expect there'll be some interest from the public regarding this matter. So, Mr. Thornton, we'll see where we go at this point. What is the township seeking if a finding against the defendants is made?
Finding of a responsibility for parking within the easement in violation of the special land use permit. Actually, paragraph 7 of that special land use permit that was signed by both Mr. Hagan and Mr. Gray. And then fines, costs, and restitution, Your Honor.
You did supply the special use permit and some of the ordinance stuff, but that's not what you're seeking. You're not seeking a $100 fine and restitution. There's more going on here. We aren't doing all this for a one-day parking violation in May. So I guess I'll learn as we go forward. Anyway, it's your charge and you have signed the formal jurat. Who do you wish to call as a witness?
I would begin with Lindsay Stauffer, Your Honor.
Good morning. Would you come right up here? Good morning. You swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief?
Yes.
Have a seat if you would, and would you state and spell your first and last name?
Lindsay Stauffer, Lindsay. Last name Staufer. FFER.
All right, there is a sworn affidavit in here from you, which I will take a look at. Go ahead, Mr. Thornton.
Ms. Stoffer, where do you reside?
I reside at 31056 Timber Run Trail.
So that is the same Timber Run Trail that Farron Hall runs beside Farron Hall, is that correct?
Yes, we're located towards the back of the closed private drive.
So you travel Timber Run Trail to get to where you reside?
Yes.
And were you present in that area on May 25th of this year?
Yes.
And did you, were you aware that there was a function going on at what we refer to as Farron Hall?
Yes.
Did you witness anything along Timber Run Trail that day?
I noticed there was parking on the easement.
And what did you see?
I saw a truck vehicle with, it looked like it had a trailer behind it. And I think there was another car also parked there too.
Did you take photographs that day?
Yes.
I may approach, Your Honor.
Yes.
Can I supply the photographs to the court?
I don't have those, or I'd screen share them.
Did you hand her all of them or just one of them?
And two of them, these two that indicate iPhone.
Thank you.
These are two copies, Your Honor, of what I handed the witness.
So this was 9:28 at night. And one was at 6 p.m. This was a Sunday. All right. Are these going to be exhibits 1 and 2?
Yes, Your Honor.
Put stickers on this. Any objection to the admission of the photographs?
No objection, Your Honor.
Exhibits 1 and 2 are admitted.
Do those photographs, Ms. Stoffer, are they an accurate depiction of what you saw on May 25th with regard to the parking along Timber Run Trail?
Yes.
And you took those photographs yourself?
Yes.
Are the photographs an accurate representation of what you saw?
Yes.
Have they been edited or modified in any way?
No.
Do you know whether those vehicles pictured in those photographs are within the easement of Timber Run Trail?
Yes.
How do you know that?
So the easement is 33 feet from the center of the drive. And that includes any grass area. It's not just the travel portion. So the vehicles are within the easement area. There's also been a survey done where there are stakes posted showing where the easement is.
So I'm interested in this easement because this isn't a public road. This is a private road.
That's correct.
So there's not a county road right of way. So I'm interested in, I don't have any documents that would establish that there's a 33-foot easement on this private road. And so Ms. Strong was shaking her head. I think she may have the same question. So anyway, I'll let you go further. I'm not sure this is the witness that has the information we need, but go ahead.
This new scam is spreading rapidly in 2025 and emptying bank accounts in seconds.
Ms. Stoffer, did you also have occasion on May 25th to see any other parking related to Farron Hall?
I saw parking in their parking lot that day.
And what did you see in that regard?
I saw it was very full. There was even vehicles in the, like the entrance of the parking lot. So it appeared to be very full.
So describe for the court the parking lot you're talking about.
So I believe their parking lot holds, I think 40 cars. I think that's about the estimate. It's located behind their property off of the easement. But it was, that day, it was very full and appeared to be overflowing.
Okay. And the photographs that you took, actually, the first one appears to have been
Here are the
taken.
pictures. All right.
The first one appears to be taken at, and this is just the way we entered them, but 9:28 p.m. Is that correct?
Yes.
And shows a white truck with a enclosed dark colored trailer, correct?
Yes.
And it's a little blurry, but it maybe 2 or 3 cars that are in front of that truck. Is that correct?
In front of the truck, I don't remember more than just the truck and that van.
The van or SUV?
Yeah,
Okay,
I don't remember more than just those vehicles.
okay. That's all I have for this witness, Your Honor.
All right, and then the other picture is just a picture earlier that same evening.
Yes.
All right, thank you. This is Casey Strong. She's representing the defendants. She has some questions for you also. You are still under oath.
So you travel Timber Run Trail often to get to your residence, correct?
Yes,
Every day?
nearly every day, yes.
And multiple times a day?
It depends on what I have scheduled that day.
Okay, and anytime you travel that road, do you pass Farron Hall?
Yes.
And tell me about this easement. How wide is it? How wide is the roadway portion?
I'm not sure how wide the gravel portion is, but our easement is a total of 66 feet, including the gravel and the sides of the gravel. And the 33 feet is on each side, starting in the middle.
You know a lot about this easement.
I do.
Yeah. So you say that there's a gravel portion. When you're passing a car, can you drive 2 cars in different directions on the easement?
Most of the time, yes.
Most of the time. And on the day that you are talking about, that May 25th day, could you pass through, could you access your property?
Yes.
And do you think another car oncoming could also access their property?
Yes, depending on the size of the vehicle.
And do you often photograph the Farron Hall property?
Yes.
Yes. On more than one occasion?
Yes.
Okay. And can you see the new parking lot that you talked about from your property?
No.
No. About how far away is that?
See, I don't know exactly how long our property is from the Farron Road and then Timber Run Trail. But it's at least a few houses down.
Okay.
We live in a wooded area that's enclosed.
Okay. So you say the Farron Hall Road, that's the city road, correct?
The county road.
The county
The
road.
county
Thank you.
road, yeah. Farron
And then
Road.
the easement, the access easement comes off of that, correct?
Yes,
Okay. And your properties are all off of that.
yes.
And did you know what the function was that day on the 25th?
I believe it was a wedding.
Okay. So it wasn't a private event associated with the business?
I don't know what you consider private event, but it was a wedding.
Okay, no further questions, Your Honor.
Just one clarification.
Yes.
Ms. Stauffer, can you see the parking lot at Farron Hall from the Timber Trail easement,
Yes.
Timber Run Trail easement?
Yes.
So you don't have to go on to Farron Hall's property to see that parking.
Correct.
All right, as I indicated, I've been there. And Farron Hall is on Farron Road. And Farron Road is a county road. Would you agree with that?
Yes.
And that's paved.
Yes.
And Timber Run Trail runs, I guess, which way is that? North?
Timber Run Trail would basically run east-west.
East-west, okay. So it runs to the, I have to look at my map again, off of it. Timber Run Trail is a private road, is that correct?
Yes.
Who owns it?
It's a shared ownership, I believe, with all of our neighbors. Because it's one way in and one way out. It's landlocked.
All right, it's a dead-end road.
Yes.
How many people live on Timber Run Trail?
There's 5 houses.
It's about a half a mile long.
Yeah.
So there are a total of 5 houses who are inconvenienced by people parking in the side of the road. Is that correct?
Yes.
Ms. Strong asked this, the way they park, does it prohibit people from going up and down the road?
Depends on the size of the vehicle.
All right, well, they don't block the whole road, do they?
No.
All right, and all right, so this private road is owned by 5 houses. How many property owners are there?
I am unsure. It's 5 or I think there's 6 houses. I forgot the Arnold's. There's 6 houses. Each of those houses own property.
All right, is there some sort of neighborhood association or something like that?
No.
All right, Ms. Strong asked you know a lot about this easement. How do you, I'm unclear about it. I haven't seen any deeded access or I'm not clear what the road status is for a private road, whether there is a presumed 33-foot easement. We may have to determine that. Why do you believe there's a 33-foot easement on each side of the road?
We have a deed that is associated to our property, and it's a deed that discusses that easement. So it outlines, I believe, the footage, and also that there should not be anything blocking or obstructing in that easement.
All right, thank you.
I have a question,
Yes,
follow up
certainly.
on your honors questions. The judge asked you about blocking of the road. During the time that Farron Hall's operated, have you seen vehicles parked within the traveled portion of Timber Run Trail?
Your Honor, I would object to this. The citation's just for the 25th.
That's correct.
But your honor raised.
I did ask, and so she did say yes. So I guess
And I would agree that we're getting a little bit, in my opinion, outside the parameters of today's hearing, which is, was there parking within the easement?
well, I'm struggling with the easement. You stated there's an easement. I haven't seen anything yet to establish that there is, and I have a concern that this is a private road and you're representing the private owners of this private road. So
I have the recorded copies
all
of the
right, so
documents.
I guess we'll get get there at some point.
And we can put those in.
I didn't see them in the pleadings.
They weren't in.
Okay. All right. Do you have any other questions for this witness?
I do not, Your Honor.
All right, thank you. You may step down, Ms. Stauffer.
I'm just looking here, Your Honor, so I don't give you duplicates. I have two documents, Your Honor. One, before I call my next witness, we'll just try to address this whole easement issue. One is a decree from the Circuit Court of St. Joseph County, recorded at Liber, I believe it's 300, page 596. And the other is an easement relocation agreement that is recorded document in St. Joseph County Register of Deeds records at Liber 673, page 351. I do not have copies of these. We could take a break and make copies. I believe Ms. Strong probably has copies of these.
Do you have any objection?
No, Your Honor, and I would seek to enter the warranty deed, Liber 1868, page 458, showing that my clients do own the property underlying.
I can bring those up to Your Honor if you'd like.
All right, let's call yours 3 and 4, and we'll call Ms. Strong's Exhibit A.
Those are mine.
And we'll make some copies before we're done. Would you mark these as plaintiff's Exhibit 3 and 4?
Talking to me?
No,
Okay.
the clerk.
Spot Pet insurance plans have covered over 500,000 pets, getting them up to 90% cash back in about 2.
We'll mark this as defendant's Exhibit A. The ruling, boy, that goes back a ways. Judge Mark Andrews, St. Joseph County Circuit Judge. That time it was still a circuit. Andrews was the circuit judge for Branch and St. Joseph County. And that is a decree by some previous owners dated January 4th, 1960. We'll take a closer look at that. An easement relocation agreement signed by our old friend Bill Drake drafted this. Some other parties, none of these parties, between easement Jasmine Beck, owner, and easement users 1, 2, 3, 4, 5. And we'll take a closer look at that. That is defendants plaintiffs 3 and 4. And defendant's Exhibit A purports to be a warranty deed by the defendants regarding their ownership of this adjacent parcel of property. All right, thank you.
Also, Your Honor, I have a, it's called a preliminary survey sketch dated March 20th, 2025, prepared by Mostrom and Associates Incorporated. I believe that also Ms. Strong has a copy of.
I believe so.
And I do not have Mostrom's here, but I think if we end up calling and the judge allows the defendants to be called in this civil action as witnesses that have been subpoenaed here, we could establish that they did recently have the easement surveyed, and this sketch is of that survey.
Ms. Strong, do you have any objection to the admission of that sketch?
I have no objection.
We'll call that plaintiff's exhibit 6.
Again, I do not have copies of this.
We'll get a copy so you've got them for your file before we're done here. Glass.
Yes, I agree. Okay, my next witness would be Pamela Stahl.
Three, 4, 5, and 6 are admitted. Oh, excuse me, I called that 6. It should be 5. Should be 5. 3, 4, 5 are admitted. Good afternoon or good morning. Would you please raise your right hand? You swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief?
I do.
Thank you. Again, would you state your name and spell your first and last name for the record?
My name is Pamela Stauffer, Pamela. Last name Stauffer.
Thank you.
And Ms. Stauffer, where do you reside?
I reside at 31056 Timber Run Trail.
And that is the same address as Lindsay Stauffer that testified
Correct.
before you. Are you related?
She's my daughter.
So you live back of Farron Hall off of Timber Run Trail, correct?
Correct.
So you're in and out or up and down Timber Run Trail almost every day, if not every day.
Maybe not quite every day, but quite often.
And were you aware of a function happening at Farron Hall on May 25th of this year?
Yes.
And you know what that function was?
I believe it was a wedding.
And what did you see that day as far as what was going on along Timber Run Trail and at Farron Hall?
Well, we saw cars parked within the easement right of way. I also saw the parking lot that was really, really full and the cars were spilling out into the bottleneck of the entrance. I also noticed, I watched a car park right behind the black building and get out for the party. So.
Did you take photos on May 25th of this year?
Yes, I did.
Ms. Strong, these are the ones that are indicated Samsung.
Thank you.
Here's a list of stuff your car insurance company does but is actually illegal. Number one, they
So I just did her. So we've got 5. So this would be 6, 7, and 8.
Ms. Stauffer, are those the photos that you took on May 25th of this year?
Yes, they are.
Do those photographs, 3 photographs, accurately indicate what you saw that day?
Yes, they do.
Have the photos been edited or modified in any way to your knowledge?
No, they have not.
And are those vehicles shown in those photos, to your knowledge, parked within the easement or outside of the easement?
They are within the easement.
And when you testified just a few moments ago that you also saw the parking lot that day, you're talking about the new parking lot that was recently installed by the owners of Farron Hall, is that correct?
That's correct.
And again, you can see that from Timber Run Trail.
Correct.
And I believe you testified, what you witnessed was that the parking lot was full.
Extremely full.
You said they were parking in the, I don't know what you
I
described
called
there.
it the bottleneck. It's where the parking, it's square and then it bottlenecks into the entrance. And
So the drive leading to
the
the
drive
parking.
leading in had cars parked in it.
And in your time on Timber Run Trail, have you witnessed, and I'm not talking on May 25th, although you could include that, but have you had the occasion to witness cars parked along Farron Hall within the easement that are in the traveled portion of the road?
You're talking anytime?
Yes.
Oh, yeah.
That's all I have for this witness, Your Honor.
Ms. Strong?
Thank you, Your Honor. On May 25th, which is the only relevant day to this matter, how long did you sit watching the vehicles?
Oh, I
About what
didn't sit
duration?
watching them.
Then tell me more about how you observed them.
Well, you drive in and out. We make that first corner and you can see who's parked there.
So about what kind of a duration was this that you saw this? Because there are a couple of different photos at different times.
Mm-hmm.
Were you going in and out? Tell me more about that.
No, there's often times on Sunday that we didn't get our mail on Saturday. So we will go out on Sundays to pick up the mail.
Where's the mail?
The mail's at the end of the driveway.
Okay,
The end of the Timber Run Trail?
Correct.
All right.
but you said the driveway, so.
Well, the end of Timber Run Trail is
Okay.
the mailboxes.
And did you notice, you said there was a car parked along the black barn. How long was that car there?
Oh, I have no idea. I don't stay there and watch them. I just notice that they're there.
And did any of these cars belong to James or Jacob?
That day?
Mhm.
I wouldn't know that.
And you mentioned you're talking within the easement. You say that phrase a lot. Can you clarify, were there any blocking the roadway?
No,
At any point, were you unable to access your own property?
no, I could access my property.
And is it true that you've engaged an attorney to civilly explore options against my clients in regards to that private easement?
We have obtained an attorney, yes.
Okay, no further questions, Your Honor.
It does not raise anything further.
I have a couple. You mentioned their parking lot was very full, parked in the bottleneck. Is that upsetting to you?
Well, it's not upsetting. It just means that there's too many people probably on the property.
Well, it's their property.
Correct.
So,
A man dealing with daily foot pain and neuropathy symptoms started using the EMSense wearable therapy device. Here's what changed.
you testified to that, and I just detected a sense of disdain in your voice that these people had all these cars in their parking lot for a wedding. And I just wondered, why would that bother you? On this particular day, did these cars that you photographed prohibit you from going out to get your mail?
No,
but this was upsetting to you. And why is this all upsetting to you?
Well, because, Your Honor, this easement is, we've lived there for over 30 years. And we were told if we do not protect the integrity of this easement, I mean, we could lose our rights.
Well, I guess you're concerned about some sort of adverse possession or something that someone else would obtain rights to your easement.
Well, it's just the fact that, how do I explain it? This all started because of the markets they were doing, and they plugged the easement both sides and outside on Farron Road. That was one of their events. And they didn't just do it once, they did it 3 times. And
This was sometime in the past?
this was in, I believe it was, the last one was fall of 23.
All right, well, let's just leave it at that. We're talking
Okay.
about something that happens now,
Okay.
but you don't like this. Is it fair to say you don't like this business being in your neighborhood?
No, I don't care about that at all. It's just that I think that the easement is very clear as far as what should be going on there. You know, blocking, impeding, all of the things that we from 1960.
Yeah, apparently people have been fighting about this easement for a long time, 65 years. And the 5 families that live on Timber Run Trail don't like it. And they have the easement. It's private. So your family or you and others have retained private counsel?
Myself and 3 other of the neighbors.
So 4 families have retained private counsel to
Well,
protect your rights?
we're all splitting the same.
Okay, I don't, that sounds like good neighbors. But so 4 of the neighbors have hired a lawyer to protect your rights?
Yes.
Okay. Does that raise any questions for anybody else?
I'm not sure, Your Honor. I guess it may. I'm concerned about the court's implication that I'm representing as township counsel, private parties here. I may ask this witness a couple of questions in that regard, if I may.
Certainly, go ahead.
Ms. Stauffer, obviously, since you've lived out there, as part of the zoning and the special land use permit that was issued to Mr. Hagan and Mr. Gray's business, you were part of those proceedings, correct?
Yes.
You attended meetings, correct? You and your husband?
I don't think we attended, but James has asked us to write a letter of recommendation. And he told us it would be a bed and breakfast situation with guests staying at the Farron Hall home and then occasional dinners. And we wrote a letter for that. Like, we were on board with it. That was fine with us.
You're talking back initially when it was first granted.
Initially.
Okay. Now, let's move ahead to when Mr. Gray and Mr. Hagan requested an amendment to their special land use permit. And there were proceedings in front of the Township's Planning Commission, correct?
Correct.
And did you attend those meetings with your husband?
Yes, we did.
And your other neighbors attended those meetings, correct? Do you know that?
Yes, they did.
You were there with them?
They were there with us, yes.
And because you're within 300 feet, you own property within 300 feet, you get a letter from the township, is that correct? Letting you know of those public hearings?
I do not think that we initially get a letter. We're just beyond the boundaries, so I think the neighbors speak amongst themselves to see who got what.
Okay.
But I think now that it has gotten, I don't know how to say it, it's getting more in depth, then we now get letters because we are part of the Timber Run Trail. I think we're just a skiff outside of the 300 feet.
Okay. And those hearings give you an opportunity to address concerns you have that may affect you and your property due to the business that the township was considering allowing on that property. Is that correct?
That's correct.
Simple. I only pay $10 a month for my internet connection. Fast, unlimited, anywhere. Have you heard about Ryoko Pro?
That's all I have, Your Honor.
I should note, I never did admit 6, 7, and 8. The 3 photographs that this witness testified to are also admitted without objection. Thank you, ma'am. You may step down.
And I have one question.
Oh, all right.
That's
Maybe
the
there's
witness
one
that
more.
was raised. How many times have you submitted photos to Mr. Thornton regarding the parking issue?
I don't know that I submit them to him directly.
How do you submit them?
I send them to township supervisor.
And how many times have you submitted photos to the township supervisor?
Oh, multiple.
Can you give me a ballpark?
I can't really. It's just
5 or more?
Oh, 5 or more.
10 or more?
Sure.
15 or more?
Probably.
20 or more?
Probably.
Okay. No further questions.
When it happens, I'll send them.
No further questions, Your Honor.
Thank you. You're free to step down. You're free to stay also. You're free to go on about your business or stay.
Thank you.
Mr. Thornton?
The next witness for the township would be Joe Klein.
Good morning.
Good morning.
Do you swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief?
Yes.
All right. Please have a seat and state your name for the record, please.
Oh, Your Honor, I was recognized as Joe Klein. I go by Joe, but my legal name is Forrest Joseph Klein. So FORRESTKLINE, the last name.
Where are you employed, Mr. Klein?
Safe Bill.
And what is Safe Built's relationship with Colwyn Township?
We are a full service building department for them.
You also do zoning administration for this, for the township.
Yes.
And how long have you been acting? What hat do you wear for at Safe Built for Colwyn Township?
I'm their zoning administrator, and I also handle any admin issues that come up for the township. I serve also as a code enforcement function when needed.
And you are familiar with Farron Hall and Mr. Gray and Mr. Hagan?
Yes, I am.
You've dealt with them multiple times, I'm assuming, at this point?
Yep, we've spoken many times.
You were involved with the building of this new parking lot we've been discussing, is that correct? And when I say involved, what was your involvement in the parking lot?
My involvement was the parking lot to be located outside the easement of Timber Run was approved by the planning commission. So my function was to just verify that it met all the requirements within the zoning ordinance. It met all the parking spaces, ADA compliant, distances from property line and easement. So it was just my job to verify that it met the requirements of the zoning ordinance.
Did Mr. Gray and Mr. Hagan have a deadline to finish the parking lot?
They were on their special land use permit. It was proposed they were given a grace period to finish the project, but I believe it was denied at that time. So their deadline was immediately following their amended special land use permit, as far as I'm aware. The township, however, chose to not pursue that, to my understanding, to give them time through the winter months and to make reasonable accommodations to give them a reasonable amount of time to get the parking lot installed, is my understanding of it.
And what was Do you have an understanding of when that deadline was from the
think
time? Let me finish question. So you're, when that deadline was from the township's perspective as to finishing the parking lot?
I believe it was unofficially May 1st was what we had talked about. And I think that's the timeline I projected to Turn Hall. And then on May 1st, there was still some loose ends that need to be tidied up. So I think we gave them an additional 15 days. I think it was May 15th was the new deadline to try and, but again, that was an unofficial deadline because there really wasn't anything in writing. That was just us working with them verbally, or, trying to communicate with them. Here's some more time to finish it up, but we really gotta get this wrapped up by this deadline or we have to start pursuing enforcement, so.
And when you're talking May 1st and May 15th, you're talking this year?
Correct.
2025?
Correct.
The government is banning this $39 electric lighter next month, and this is your last shot to get the original.
Can I approach the witness? Certainly. Showing the witness exhibits 6 through plaintiff's exhibits 1, 2, 6, 7, and 8, which are the photos the plaintiff has entered. Go ahead and finish flipping through them. As zoning administrator, are you familiar with the easement we've been talking about, the easement for Timber Run Trail?
Yes.
Do you know, has that easement recently been staked and surveyed?
It has, yes, by most drums.
And have you seen the survey for that easement?
I have, and the stakes as well.
So you've been out on the property?
Yes.
And saw the survey irons that are put in by the survey?
Yes.
So you're familiar with the boundaries of that easement?
Correct.
How wide is that easement?
To my knowledge, it's 66 feet across total.
And in reviewing those photos, the vehicles parked and shown in those photos, can you testify as to whether, to your knowledge, those are within that easement or outside that easement?
I believe they are within the easement. If memory serves correctly, the fence is 2 feet outside of the easement where these vehicles are parked in front of the black building. So if they were within, outside that, they're well within the easement.
When you say it's 66 feet across, what do you mean?
The entire width of the easement, I believe, is 66 from one side to the other.
So it includes the road?
Yes, if I'm not mistaken, the driving portion of the road hugs the north side of that easement, if I'm not mistaken, sir.
All right. So how wide is the road?
Is Your Honor asking how wide is the traveled portion of the road?
Yes.
I have not measured that. I would estimate it somewhere around 20 to 24 feet in that area. I have not actually measured that to see. I think it might be on the survey, though. I think it was delineated on there, if I'm not mistaken.
So the road hugs the north side of of the easement?
That is how I remember it, yes.
So the easement's wider on one side of the road than it is on the other?
Yes, and that's common, Your Honor, for the easements to either start out in the middle and then wander one way or the other, or vice versa. They're not always directly in the center. And unfortunately with zoning, I run into this issue a lot. Some people are basically at a disadvantage.
All right. So we have a survey that I guess will help answer this question. So it's your understanding that the fence is 2 feet into the easement and anything between the fence and the edge of the road is within the easement?
So it's 2 feet outside the easement, Your Honor.
All right. So the fence is not within the easement. So 2 feet from the fence to the edge of the road is the easement
Yes,
on this side?
correct.
And I believe, and I know it's hard to see, but that's what was submitted to the township, that size of the survey. But for clarification, I believe the survey that has been admitted as an exhibit shows most of that split rail fence being outside the easement, with some of it being within the easement because it does jog. So that's all shown on that survey.
And as we discussed, it's hard to see it, but all right. He's, okay. At least on that side of the road. Okay, thanks.
That's all I have for this witness, Your Honor.
Ms. Strong?
This is the viral hack that is making people rich.
Were you recently injured in a car accident?
Thank you. Mr. Klein, can you remind me, how long have you worked for Safe Build?
Just over 6 years now.
And during that time, how long of that was spent in affiliation with the township?
The whole 6 years.
So it's fair to say that Safe Build is an agent of the township.
Yes.
And do you attend all of the town hall meetings?
No, I do not.
Do you attend most of them or some of them?
I attend when requested.
Okay. And who makes that request?
Usually the township supervisor or someone from the township.
And so were you working for Safe Build back when my clients bought the property?
No, I was
No.
not.
At what point did you start working for Safe Build? What year?
It was 2019.
So you were employed by Safe Build when they proposed to build that black barn, correct?
Correct.
Do you remember the plans for that black barn being submitted?
Yes, there were some plans submitted for it, yes.
And did you, as your job with Safe Build, you approved those plans, correct?
I'm going to object on relevancy, Your Honor.
Your Honor, they're relevant to the parking and whether or not the parking was ever delineated to be within the easement.
I guess we'll find out. The black barn is inside the fence on this side, right where these cars are parking. Is that correct?
That's correct.
All right, I'll allow it and we'll see where we're going.
If I could just follow up and put something on the record here. I believe where Ms. Strong is headed is an argument that they're somehow allowed to park, or their guests and anybody attending functions there are allowed to park within the easement. That has been something that has been before and between these defendants and the township, and was resolved with the special land use permit that was approved by the township and approved by the defendants.
All right, well, we'll see where the township doesn't own the easement.
That's correct.
It's owned by the private owners on Timber Trail. But obviously, your point is this was discussed at the time the black building was constructed.
Yes, Your Honor.
All right, well, let's see where this goes.
And when the black
And
building,
the special use permit is in the pleadings. It's not yet in as an exhibit, but we'll get to that.
when the black barn plan was submitted, did it show delineated specific parking within the easement?
I don't recall without having it in front of me exactly what was delineated on there.
Your Honor, if I may, proposed exhibit B for the defense shows the site plan that was approved by Safe Build. And I believe this has been furnished to Mr. Fortin in the past. If you could hand that to Your Honor once you refresh your memory.
Your Honor, if I could have just a running objection to all these questions.
All right, thank you.
Based on relevance.
Again, these are very small. This is, let's mark this as defendant's exhibit B.
And that exhibit shows parking along the backside of the black barn, correct?
That is correct.
And
Stop. Well, let me catch up. Mr. Klein, is this your document?
I'm not sure, Your Honor, where that came from. It could have been one of our documents that was scanned and uploaded or sent over to them.
All right, so the site plan, and subject to Mr. Thorne's objection, envisioned parking in this area?
Correct. At one time it did.
All right, and,
It was presented that way at one time, yes, Your Honor.
all right. All right, any, subject to Mr. Thorne's objection, exhibit B is admitted.
Can I take a look at it, Your Honor?
Yes. It's hard to see it. Thank you.
All right, let's talk about that. This hearing with Judge Middleton really showed why he's.
Watch this before eating olives.
Olives, they're actually a great source of fiber, which feeds your friendly bacteria.
All I got is parking, gentlemen. You got a ticket. People that had come to your event parked in the road. Somebody, probably part of the wedding group, had a enclosed trailer. There wasn't anywhere else to put it. So they parked it in the road right of way. I had a concern whether the township does have the authority to, as she said, if they can't grant permission to park there, do they have the authority to restrict permission to park there? But you entered into an agreement that said you wouldn't park there, which answers the question. But yes, I've been to the facility. The buildings are very nice, and they probably are in the neighborhood of millions of dollars. So there are a number of issues in here which restrict their ability to operate the business. Number of employees, number of guests. I don't have a position regarding that, because that's not before me. It's just this parking issue where a truck and a trailer and maybe one or two cars were parked in the road right of way. It wasn't with their blessing and consent. Their testimony is that at this point, now that they have the parking lot, they have an employee that stands out there and says, hey, you can't park here. And frankly, it looks like a place to park, which is why I parked there when I went there last November. But it isn't. And now they have a parking lot. So I don't know. So the neighbors, two neighbors in the same house, took a picture the day of the wedding of some cars parked in the easement. I mentioned also, you're not subject to any criminal penalty. This is a civil infraction, punishable by a fine only. The ticket states that the fine is up to $250. $26,400. When I saw this case had been authorized, I thought, oh, great. I wish it wasn't me, but it is. I wish it wasn't me on your other case either, but it is me now. Judge Stutzman had a conflict, so we don't get to pick. The judge gets what cases are brought before him. So let's look at the actual allegation. Ticket says, it's hard to read it. It's really hard to read it. By signing the permit holder agreed to not park within the easement. And the allegation is that they violated section 26.4. So the allegation is that they're somehow violating their special land use permit. But I'm not sure which section of the, so let's look again at 26.4. By signing special land use permit 1014-24B, agreed not to park within the easement. So it says it violates the zoning ordinance. The allegation is, I guess, that they're violating the special land use permit.
That's correct.
All right, so what section of the ordinance? Let's go back to 26.4.
On page 80 of what I supplied to the court in Ms. Strong, paragraph 7 of the zoning ordinance.
All right, well, let me get to there. Page 80, we got a ways to go here.
Criminals are using tools that allow them to roll back odometers for
Ordinance 205. Way down here.
Should have been before ordinance 205.
All right, I'm getting close. 78. 79. Which paragraph?
7.
All right, paragraph 7. This is what you're alleged to have violated. Conditions and limitations in addition to those specifically enumerated in the zoning ordinance may be made part of any permit granted in order to protect adjacent properties, the general neighborhood and residents, to make the proposed use comply with the intent and purpose of the zoning ordinance, other townships, ordinances, and state and federal laws and regulations. Any conditions and limitations imposed shall be specifically set forth in the permit granted and shall remain unchanged except upon mutual consent of the planning commission. All right, so where's the punishment portion of that?
That's the general 26.4. The permit, the special land use permit is granted under the zoning ordinance under this whole chapter 16.
And if I may ask a question, unchanged except upon the mutual consent of the planning commission and the landowners, the ticket specifically states that there was that parking lot that was supposed to be finished by X date, but that was never in the special land use permit. That was changed.
Well, what does that mean?
The planning commission stated on the citation that there was an extension for putting in the parking lot, and they were in violation of that.
Well, from the ticket itself, it's hard to figure out exactly what the allegation is. We're trying to sort it out. So let's go back to the violation section. Well, the first 5 sentences don't apply. Ordinance continues, constitutes a separate offense and shall be subject to increased fines and penalties as provided by section 11 of the civil infraction ordinance. All right. The owner of any building or land where anything in violation of this ordinance shall be placed or shall exist, any architect, builder, contractor, agent, person, or entity employed in connection therewith. Well, where does it say violation of a special use permit is subject to this section?
Your Honor, it's the first sentence that you originally said doesn't apply. Any owner or agent, any person or corporation who shall violate any provisions of this ordinance or fail to comply with any requirements thereof. The special land use permit is granted under section or article 16 of the ordinance. It's just like all special land use permits, variances granted by ZBAs or zoning boards of appeals. Those are all done under the zoning ordinance.
So we'll put the period after thereof. Any owner or agent and any person or corporation who shall violate any of the provisions of this ordinance or fail to comply with any of the requirements thereof shall be guilty of the civil or responsible for the civil infraction. So let's go back to page 8, section 7. Still kind of struggling here because it isn't very clear, but I think it is intended under the general ordinance. Conditions and limitations in addition to those specifically enumerated in the zoning ordinance may be made a part of any permit which we have granted in protected adjacent properties. And they failed to comply with the terms of the permit. So as a layperson, if you got this ticket, you would have a really hard time figuring out exactly what it is you did that was the violation. I'm the judge, and I'm having trouble figuring out exactly what it is you did that violated it. The jurat, the ticket itself, doesn't give very much notice.
A man dealing with daily foot pain and neuropathy symptoms started using the EMSense wearable therapy device.
It just cites the zoning ordinance, with that first sentence of which is relevant, as Mr. Thornton has argued. And the stuff in the ticket, it was written by Forrest Klein on 6/10.
Joe Klein.
Well, he signs it Forrest Klein. Has stuff continues to park within the easement. It doesn't matter whether they finish the parking lot or not. Not to park within the easement and continues to park within the easement. So it's a civil infraction. And the burden of proof is one of probable cause, which is just barely more than not. In a criminal case, the burden is beyond a proof of beyond a reasonable doubt. They cited both of you separately for the same violation. I don't know if this is owned by a corporation or privately owned, but you've each got cited with a civil infraction for somebody parking in the easement that you may or may not even know there. The township wishes to argue for restitution. And again, let's look at the sanctions. $26,400. Shall be subject to fines, costs, and sanctions specified above. So I guess I'm not sure what costs are. If costs are, what if the court assess fines and costs? Fines go to the library, costs go to the court. I'm not sure, but they're asking for restitution. Mr. Thornton?
Safe Built has cost of $410 from issuing the citations through today's hearing, and my office has $1,800 in this through today's hearing.
For 3 cars parked in the easement on May 28th. Ms. Strong, what's your position?
Your Honor, I would ask for discretion if the court is going to find my clients responsible for 3 cars parked in an easement. It should not be a matter of paying legal bills that have stemmed from a long history with this case that has required preparation. My clients have retained counsel. They've had retained counsel at every step of this case. They have invested substantially in the property, substantially in their legal defense. And we're not even talking about the hundreds of thousands of dollars that it took to put in this parking lot. Parking lots aren't put in overnight. They require time and effort on all parties involved. So I would object to the restitution.
Well, I'm not other sanctions. The ordinance is sort of unclear. The ticket says it's $250. The violation section doesn't say that. Any agent, owner, or person who violate any provisions of this ordinance or fail to comply with it thereof is responsible for a municipal civil infraction subject to payment of a civil fine of not less than $50 or more than $500. So it's not set at $250. I think that may be their fee schedule or something, or maybe the courts. Plus cost and other sanctions.
On August 22nd, I told viewers that the road to artificial general intelligence was already
Your Honor, as we do in other civil infraction cases, it's actually the civil infraction statute that gives the court the discretion to order restitution.
Well, it's under cost. It isn't restitute, but the court does have the discretion. This says is responsible for a civil infraction subject to payment of a civil fine of not less than $50. So it's subject to, it doesn't say shall. It says is responsible subject to payment This ordinance is unclear, but the fine is not less than $50 and more than $500. All right. Each defendant is cited separately. I'm struggling with the actual violation, and it was hard to distill this down to what it actually is. The allegation is on that day, a truck with an enclosed trailer, a van, and perhaps a third car were parked in the easement somewhere between afternoon and evening. The easement belongs to a private entity, not the township. So defense argues if township isn't responsible and can't grant permission to park there, do they also have the permission to say you can't park there? But you entered into a voluntary agreement saying you would not park there. And I don't think that the parties there parked there with your permission and consent. There's more going on here, which is I'm trying to set aside. It isn't as though the defendants went out and encouraged people to park in that road right of way. Now, there's been much previous parking in the road right of way before they had the parking lot. Now they have the parking lot, which I fear isn't big enough. They're only, for reasons I don't understand, only allowed to have 80 people in there. Not very many weddings have less than 80 people invited. They only allowed to have so much staff. That goes to something other than this parking issue. So we're seeing the tip of the iceberg. The township grabbed this tiger by the tail on behalf of the people from Timber Trail Run and hired Mr. Thornton to bring this action. I'm gonna order a $100 fine for each defendant. Not ordering any costs. Township went into this with their eyes open. Defendant has to hire their attorney at considerable expense on this civil infraction. I'm not going to order that they pay the township's expense in addition. Mr. James Gray, you'll fine at $100. It's due 30 days from today, which is September 8th. That is in file 251080. Mr. Jacob Hagan, you are also fined $100. File 251079 ON. It's also due September 8th.
For clarification, is the court finding them responsible for the parking violation?
Correct. Each defendant is charged separately as responsible for the parking violation, primarily on the basis of the use permit that they signed and agreed to. I think they're going to be much more diligent about it now. Now they have a parking lot. The parking lot isn't big enough. They needed more than 40 cars, but I'm not sure exactly the lay of the land. If you have 80 people, that's 2 people per car. And
Why you should never charge your smartphone at night. 22 years as a cell phone repair.
But yes, they're guilty of the violations. You can pay that today. You can pay it with credit card. You can send a certified check or money order, or you can pay with good old-fashioned green cash. or a credit card. The offense cited, I found you responsible for beyond the preponderance of evidence, and I assessed a fine that's over the minimum but less than the maximum.
All right, let's talk about that.
That's pretty bad. Oh boy. Well, I mean, that's it for today's docket. Tomorrow's landlord-tenant docket. I did add Judge Manning and Judge Washington to the docket, to the streams. So I removed two and then put Judge Manning and Judge Washington in because I got enough stuff. I got enough stuff to show that. Again, if you're not a subscriber to this channel and you like the content that's on this channel, please consider subscribing to this channel and helping this channel grow. That's all I ask, is help make this platform better than it was. Yeah, so I will be covering Judge Manning now. I got a bunch of Judge Washington. Like I said, I appreciate everybody that comes in. Sometimes people come in here during the week, some people don't. I notice the views come up on certain ones, and then there might not be views on other ones. It doesn't matter to me. I'm just here to educate people on what the judicial system is and how it works. What? Now, wait a minute. Such language out of you guys. You're a bad influence on me. Yeah, I like it doing this better. You know, I don't know who it was that made that suggestion, but I like doing this. And I do a lot of research on judges and court cases and stuff like that. It's like I said, every once in a while, I'll mix it up. Such language from you guys. You guys are such a bad influence on me. Oh, Lord have mercy. It's been a long week. Do you guys realize that I put out 140 live streams? Over 140 live streams since this channel became able to live stream? I've been doing everything I can to try and save this channel. I do appreciate Trin and Linda and Gail and the moderators on this channel. It's like I said, the no-fly list has been erased. Everybody has a chance to come on here and everybody has a chance to speak their mind as long as they keep it civil. Have a good one, John. So I'm going to go ahead and call this one. Some I will see tomorrow. Some I will see on Monday. So you all have a good evening. Thank you for watching and thank you for supporting my channel. Like I said, if you're not a subscriber to this channel and you like the content that's on this channel, please consider subscribing to this channel and helping this channel grow. And like I said, everybody is welcome here as long as you act civil. Yeah, it's been a long, what, 4 months now? It's been 5 months, starting 6 months that I've started this channel. I've been working on this channel. It's been long. So I don't know if I'm going to if I have a doctor's appointment on Monday, and my birthday is on Tuesday, the 7th, and I don't know. I think it's just going to be a regular. I'll do Judge Flesher, and I'll do it in the evening. It's okay. It's okay, Linda. I understand. I'm not mad at anybody. I'm here every day doing my thing and trying to educate people on what the judicial system is. What? Well, you get your vocabulary. You're all going to get me in trouble on YouTube. So I think it's just going to be a regular schedule, it depends on what time I get home from the doctor's office, is what time I actually come on. So I will probably be waiting on that. And Tuesday is my birthday, and I'm going to be here. And I think Tuesday is Judge Simpson. So Tuesday will be Judge Simpson. It'll just be regular business as always on the channel. I don't want no special. I don't want no special. I'm not going to do anything special. I'm just going to come on here and do my thing. With all that said, I'm going to leave you for tonight. You all have a wonderful evening. Some of you I will see tomorrow with our landlord-tenant docket. If I don't see you, you have a wonderful week and have a wonderful rest of your weekend. Ta-ta, ciao. I will see you again soon. And thank you for watching, and thank you for supporting my channel. Thank you, Trin.
Breakdown, you're the one I call. From the mountains high, come down to it all. With your tools in hand, making magic flow. Every broken part, you help me grow. You fix it all, you fix it all. Daniel, you make it right. Daniel, everything's right. When I'm falling apart, you put me back together. Daniel, you make it better. From the wires tangled up to the broken dreams, you know how to mend all my scattered seams. With your steady hands, you refill my heart. Every piece that's lost gets a brand new start. You fix it all, you fix it all. Daniel, you make it right. Daniel, everything's bright. When I'm falling apart, you put me back together. Daniel, you make it better. Fix it, Daniel. Make it right. When the world shuts down, and I can't see clear, you're my solid ground, always drawing near. Never give up on this heart of mine. Put it back together every single time.